restraining order often isn't the final word, and here's ways that it can be dismissed. So a lot of times we have clients that have restraining orders that have been filed against them, and their number one question when they hire us is, can this be dismissed? And if so, how do we do that? There are many ways in which a restraining order potentially can be dismissed. First and foremost, it can be dismissed on its face, meaning a petitioner files a restraining order with the court. The court reviews that petition and says, hey look, there's not enough here to where I think that there is enough of a threat that a restraining order is needed to protect this party against this other party. Now let's say the judge decides there is enough to get to a hearing. Now at this hearing, it works like a mini trial. Both sides will be able to present evidence, give testimony, and show why they should or should not have this restraining order either granted or dismissed. Now, throughout the hearing, the judge may determine that there isn't enough evidence to go forward, and after hearing the evidence, the judge may say, look, based on what I've heard and seen today, there's not enough for me to grant this restraining order, and the judge may dismiss it based on a lack of evidence. Now, additionally, if a restraining order is filed and the judge grants it for a hearing, the hearing happens, the other side doesn't show up. Well, the judge is going to say, was there proper service? Meaning, did the other party have adequate notice that this restraining order was filed, and did they know that they needed to be here today? Because we can't file things in this country where the other person doesn't have notice and expect a judgment to be granted against them when the other party has absolutely no notice to be there to defend themselves against these allegations. So if it comes to light during a restraining order hearing that the other side wasn't properly served, the judge could dismiss it on procedural grounds saying, hey look, there's enough to go forward, but because there wasn't proper service, I'm going to dismiss this. Now, the person that filed the restraining order could then refile, assuming that they can get perfect service. That way that person has notice and can get in front of the court. Now finally, the last way a restraining order can be dismissed is if the person that filed the restraining order asks the court to dismiss it. And oddly enough, we see that quite often. Someone's very mad at their significant other, very mad at their neighbor. They don't have enough time to cool it down. They file a restraining order. Days go by, weeks go by, they calm down. They realize, hey look, I did that in the spur of the moment. I really don't want this restraining order. I don't want to go to court. I actually want this person in my life, etc. If the person that asked for the restraining order notifies the court that they want that restraining order to be dismissed, whether that's before a hearing or even after it's been granted, if the moving party, meaning the party that asked for the restraining order, asks the judge to dismiss it, the judge does have the ability to go back and dismiss it before it comes to fruition, meaning before it's granted, or if it's been granted and say a couple months go by, the person that filed the restraining order now wants to get back to the person they filed it against. Judge, I made a mistake, I'd like this to be dismissed. The judge can terminate it at that point as well. If you're facing a restraining order, I know we can help. Give us at the Marc Lopez Law Firm a phone call, 317-632-3642, and always remember, plead the fifth.